Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
All right. This is State of Michigan versus Deshaun Thompson, case 24044-90301. Today is the date set for a bond redetermination hearing. Appearances, please.
Morning, Your Honor. Samuel A. Ragnone, P23-157 on behalf of the.
Good morning, Your Honor. Jessica Shine, P number 81798 on behalf of Mr. Thompson. Mr. Thompson, please state your full name for the record.
Under duress. My full name is Deshaun Thompson.
All right. Thank you, Mr. Thompson. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable at $100,000 cash or surety. Ms. Shive, as to bond.
As to bond, I believe this bond is very excessive. This is a misdemeanor. Allegedly refusing to get fingerprinted. To my knowledge, no criminal history, not on probation, parole, nothing pending, lifelong resident. This is non-assaultive. Respectfully asking the court to consider a personal bond. Unless I'm missing something here, I don't know why a bond this high on a charge like this.
Okay. Mr. Ragnar?
Your Honor, we think the bond is appropriate and we're asking for it to remain in place. If the defendant was able to walk out of jail without providing his fingerprints in the charge, that would not fit well with other charges that he had pending or future charges that he had. And he does have convictions, Your Honor, back in 1031-13, interfering with a police officer and malicious destruction of property, $200 to $1,000. 6/2014 police assault, resisting and obstructing. He had a drug charge also. 3719, pled guilty to police assault, resisting and obstructing. Was discharged from Michigan Department of Corrections on 9/13/21. He had a sentence on 2/26/20 for police assault, resisting and obstructing. And sentence 3, he had an attempt controlled substance, 25 grams or less, discharge 5/9/19. He's got a history. He's got an assaultive history with, I think, 3 assaulting and resisting matters. And we're asking that the bond remain in place.
Yeah, may I respond very briefly?
No. All right. I'm going to set bond at $100,000 personal. Mr. Thompson, your next date is going to be July 29th, 2024, before Judge Bryant. I am going to remove the tether requirement. Mr. Thompson, excuse me, July 29th, 2024, before Judge Thomas. Strike that, before Judge Bryant. You're going to get paperwork with that information on there. Sir, I would suggest that you signed up for text reminders or email reminders if you want to make sure you make that date. Do you understand?
Okay. Is this a court of record?
I'm sorry?
Is this a court of record?
It is.
Okay. You judge who again?
I'm Judge Williams.
Judge Williams. And what judge am I CNX on the 29th?
Judge Bryant.
Okay.
All right. Then that concludes this hearing.
Thank you, Your Honor.
You're welcome. Mr. Flanori, can you hear me?
Good morning, Judge. I am going to put him.
All right. Thank you. All right. Mr. Nyheis, Ms. Murphy, maybe I'll call you a case while they're talking. All right, this is State of Michigan versus Dawn Coleman, case 24057825501. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable. Appearances, please.
Good morning, Your Honor. Crystal Murphy on behalf of the people, PA.
Good morning, Judge. Patrick Nienhuis, P76343, on behalf of Mr. Zahn Coleman, who's present. We consent to a Zoom hearing today.
All right, Mr. Coleman, sir, could you state your name for the record? Mr. Coleman, they might have to put that that Zoom device a little closer to you because we can't hear you. But I understand that you might be on some medication right now. Because it looks like you're trying to talk, but we can't hear you from here. All right, thank you, Mr. Coleman. Today is the date set for the bond redetermination hearing. Bond is set intentionally unaffordable, $500,000 cash as surety. Mr. Nyheis has the bond.
Judge, just like I said to the magistrate a couple days ago, I'm asking for a personal.
Mr. Nyheis, we have to stop right here because I have no idea what you said to the magistrate. I hear these as a de novo hearing, so just make total argument.
I'll make it all. Okay, thank you, Judge. So I was going to say, I'm asking for a personal bond, and I know this is an egregious allegation and it's a serious crime, and Mr. Coleman should never be driving and never should drive. But the reason I'm asking for a personal bond is because after he got in the car accident that caused what he's here for today, he has broke every bone in his right leg, it's my understanding. He is on serious pain medication. He's going to have months of physical therapy. And who knows if he's going to be able to even walk again because, like I said, every bone in his right leg is broken. He's got a terrible driving record. I agree that, but there was a way to make sure he doesn't drive because he can't even use his right leg right now. There's a protection of the community. He's never had a failure to appear on my cases that I've been retained on. He has skipped traffic tickets, which is not allowable or anything, and there's no excuse for that. But he will not be a flight risk now. He'll be bedridden. He will most likely have to have a bedpan. He won't get adequate treatment in the Wayne County Jail. I can attest to that. I've had many clients with serious injuries. So I'm asking for either $100,000 personal bond, and I don't want to ask for a GPS tether because I want him to be able to go get his physical therapy and stuff done. But I would ask that he get sentenced to house arrest with his mother. And after that, he'd be allowed to leave just for attorney's visits and medical reasons, Judge. There's no way the Wayne County Jail can make sure he can recuperate fully. I understand this is a serious crime. So if the court's not comfortable with the personal bond, I would ask for a $100,000 10% bond, which would allow Mr. Coleman to hopefully use a bond agent to maybe get out. And on that case, he could it's basically, I want him to be home and be able to go to his physical therapy, go to the hospital, get the follow-up treatment. He had surgery on, I think it was Monday, and was not released in time to have the arraignment on Monday. So he did the arraignment on Tuesday. He was on extreme painkillers, Diludad, I think it's how you pronounce it, oxycodone. He's got no prior felony history, no prior assaultive history. This was an accident. Just got some discovery, so I don't know much about the case. So I'm gonna leave most of it in Miss Murphy's hands on describing the case. But I'm asking for a fair bond that would allow Mr. Coleman to get out and get the medical treatment he needs. He will not be a flight risk. He was on bond for a misdemeanor, improper transportation. The gun was legally purchased. Everything was done correctly on that thing, except he was carrying it the wrong way. So I'm asking for a personal bond, or at least 100, or at the most 100,000, 10% bond. Thank you very much, Judge.
All right, thank you, sir. Ms. Murphy?
Thank you, Your Honor. Your Honor, first and foremost, the people are asking this court to leave bond exactly as is. In regard to the defendant's current condition, it's the people's position that he put himself in that medical condition, and unlike his victim, he will heal. The driving record here is 25 pages long. He's had 6 citations this year alone from 3 separate incidents, including disobeying a traffic signal and reckless driving. It appears his license has been suspended since 2013. It also appears he has had 82 traffic violations, including 3 prior at-fault crashes, 2 for hazardous action and 1 for disregarding a traffic control device. Nothing is preventing this individual from driving. Nothing. Probation, fines, nothing. And although this isn't assaultive, Judge, the people's position is that this is just as dangerous because his zone of potential victims is anyone. The victim in this case appeared to have simply been pulling into a gas station parking lot. It's about as normal a thing as anyone can do. And as this court knows, murder is one of the few charges where a defendant can be remanded. Here, it's the people's position that the magistrate who arraigned the defendant got it right. In weighing the history here and weighing the danger to the community. Again, the defendant at some point is going to heal, and it's the people's position that he will get back behind the wheel. And there's too great of a risk, there's too great of a danger, and the bond here is appropriate, taking into consideration his atrocious driving record. And again, although that this conduct isn't assaultive, it is just as dangerous in that truly anyone can be this defendant's victim, as what happened here is this victim was just going about his life simply trying to turn into the gas station parking lot. So with that, Your Honor, the people would respectfully ask that bond be kept as is.
All right, give me a sec. All right, I've had a chance to review the information. And you both made good points as to why Mr. Coleman should be released and why Mr. Coleman should be detained. Bond is set at $500,000 cash right now, which is essentially a detainment. And I have to balance that with the safety of the community as well as flight risk. Understanding that these are remandable offenses, or as Mr. Coleman is charged with murder in the 2nd degree, but with a high likelihood of, well, the evidence is strong in this matter. I don't know if it's a high likelihood of conviction, but the evidence is strong in this matter that the defendant could be detained without a bond, but bond is set at $500,000 cash. So I'll give you a little analysis why I believe this bond is going to stay the same. Mr. Nahas, you indicated that your client cannot drive right now. You indicated that he's got a broken leg as well as some other injuries as a result of this accident. And I do believe that would prevent the defendant from driving in a car. I would also note that, I'm looking at traffic offenses, and whilst most of these are tickets, a lot of these matters do involve someone driving in a dangerous manner, a very dangerous manner. I've got a warrant out for reckless driving. I've got a warrant out for operating while intoxicated. I've got a warrant out, 3 warrants out for driving my license suspended. And outside of the OWI, these are all this year. So there was a history of driving, in a manner that would have led to this led to something like this. And while the defendant cannot drive right now, he is being charged with murder as a result of this incident. And I'm not saying he's at fault, or because these are allegations at this point. Somebody's dead. Somebody's dead, and whatever the actions are, I have somebody with at least a history of being charged with actions like this. The magistrate didn't remand the defendant at the preliminary strike at the arraignment and set up potentially unaffordable cash bond. And I'm going to keep it there. I do believe that there are clear and convincing circumstances or why this person would be a danger to the community. I don't know the extent of the injuries, but I do a broken leg is probably not likely to drive. I have a capious history, and while these aren't felonies, these aren't misdemeanors, these are traffic offenses, but this is a traffic offense. This is exactly the situation where the defendant doesn't show up for. So I do believe that there is a flight risk, regardless of that situation. So bond is going to remain the same at this point. The next date will be before Judge King. June 25th, 2024 at 8:30.
Thank you, Your Honor.
Judge, can I request a DSA report from you, or should I wait till I'm in front of Judge King?
I'll order one now.
Okay, thank you very much.
You're
I
welcome.
appreciate it.
No problem. Good to see you both.
Good to see you too.
Good to see you too, Judge. Take care.